Namaste, Pranam. I'm Ram Singh, legal advisor SLA. Today I have a topic on insurance claims, cases and discussions. There are several cases or certain cases which were fought by the insured people, and after a long fighting, after a long litigation fighting, the decisions were given by the Supreme Court of India or the National Commission. Actually, all decisions are from the Supreme Court of India, and Supreme Court of India is supposed to the last resort. That's why all these decisions, all these decisions bear some power and ability to be accepted in the arena of the insurance industry and courts also. Policy exclusions, regulator compliance, scope of coverage are legal land scope for policy holders and insurers both. Supreme Court of India, citation civil appeal number 355-374 of 2024, Supreme Court emphasizes that the importance of clear and unambiguous policy language, ruling that any ambiguity should be construed in favor of the insured. If there is any ambiguity in the policy and on basis of interpretation, the profit or any benefit of doubt will go to the insured people. It is the ruling of the Supreme Court. Disclose our material terms to the policy holders. It is the duty of insurers to disclose all material terms to the policyholders, as I told earlier. This judgment reinforced the necessity to draft clear policy and insurers' transparency in dealing with the policyholders, and court also underscored the principles that ambiguities in the insurance policies contract are to be interpreted in favor of the insured in order to protect the interest of the policyholders. It is duty and responsibility of the surveyor and loss assessor, investigators, insurance companies, and who are involved in the claim process. They are supposed to give favor or any benefit of doubt to the insured person. It is also a ruling by the Supreme Court too. Case number 2 है citation civil appeal number 2955 of 2022 Supreme Court India में केस था. Other insurance clauses interpretation, whatever the other insurance clauses interpretations are concerned, the Supreme Court examined the interpretation of the insurance clause in insurance contract to other insurance clause must be interpreted in manner that does not unjustify and unjustly benefit the insurer. Unjustly benefit the insurer. Insurance company or insurer cannot repudiate or reject the claims on basis of their beams. And the ruling emphasized the insurer cannot escape liability by relying on the existence of the other insurance policies unless explicitly stated in the clear term. In this case, the ruling ensures that the policy holders should not unfairly disadvantaged due to overlapping in insurance policies. It mandates insurers to clearly specify the implication of the other insurance clause and thereby promoting fairness and transparency in the insurance contract. Whatever the insurance contract were there. Actually, overlapping of policy means कि if a person has one policy, any company, person may be the company, any company has one policy, and another head of that company means जो sister company or parental company has taken another policy. On basis of that, any insurance company cannot reject the claim, repudiate the claim. Justice Uday Umesh Lalit and Justice Ravinder Bhatt has given decision on this point. Case number 3 is civil appeal number 4261 of the 2019, and Supreme Court held that the insurer has the right to reject claim if it is proved that the insured has concealed material fact. If any material fact, the fact that impacted to the claim is a material fact. Any material fact influence the insurer's decision to issue the policy. Insurance company can reject the claim, repudiate the claim. Non-disclosure of material information by the policy holder may reject the claim. Reliance Life versus Rekha Naresh and Naresh Bhai Rathod. Implications but the judgment given by the Honorable Supreme Court underscored the full and honest disclosure of the policyholder and also highlight that the insurer's right to deny claim based on the material non-disclosure is a right, thereby promoting integrity and insurance contract promotion process. Integrity means कि whatever there should be, that should be in a integrity way, transparent way. Case number 4 है, insurance companies are supposed to adhere strictly to the legal and regulatory framework to avoid substantial penalties and the reputational damages. Any substantial penalty and reputational damages, whatever the reputation are there, it means that key insurance companies are supposed to maintain the decorum and they must follow the regulatory guidelines and regulatory systems, and they cannot avoid all that. If they are avoiding the legal and regulatory framework set and established by the government of India, means that they are doing business in a dishonored manner. GST Directorate accused Aviva India and using the fake invoices and cash payment to evade taxes and circumvent commission caps between 2017 to 2033. पाँच सालों तक इन्होंने evade किया. The investigation revealed that Aviva illegally funneled rupees $26 million evade किया इन्होंने टैक्स को एंड रेगुलेटरी कमीशन लिमिट्स रिजल्टिंग इन एन टैक्स इवेजन ऑफ $5.2 million. These cases are the example and the highlighting the evolving complexities in the insurance law, and all these decisions were expressed before you in order to highlight the decisions and also the points that could give you some knowledge. Thank you very much. Like, subscribe and share.